Hello, welcome to Designation of Expert section of the ULB Justice Center. Happy to have you here. Disclaimer: the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Where are you in the process? What does Designation of Expert mean? This point in the process is a continuation of discovery and preparation for litigation. Designation of expert is a process of any party being able to demand for exchange of information concerning each other's expert trial witnesses. Once the demand has been received, the party can either provide the information or, if there is a reason not to provide the information, file a motion for protection order. The party being served with the demand may then move for the protective order. A protective order in discovery protects the person who would have otherwise have to provide discovery. A requirement for this motion is that parties will meet and confer under Section 2016.040 to try and resolve the issues before the motion is filed. A meet and confer declaration should, quotation, state facts showing reasonable and good faith attempts at an informal resolution of each issue presented by the motion, end quotation. This information can be found under California Code of Civil Procedure Section 2016.040. In order to accomplish this, two parties will meet and have meaningful conversations to try and resolve issues. If issues are not resolved, then a declaration will get attached to the motion to show the court that this step was done. This declaration can be written on a pleading paper to explain the issues that were not resolved. If there is no reason not to respond, then you will respond to the request. Additionally, it is important that you send a demand to the opposing party in your case so that you know if they have an expert, who they are, and what they plan to talk about. This will allow you to prepare. What is the purpose of this step? The purpose of this step is that the exchange gives opposing parties enough information and time to prepare for trial. It also gives the opposing party the chance to research, depose the expert, and gather information and evidence in the specialized field that could be useful during cross-examination of the expert. Cross-examination is the opportunity for a party to ask questions in a court of witness who is testifying in trial on the behalf of the opposing party. If you are not using an expert witness, you must state that fact. If you are using an expert witness but do not disclose this information, give an expert declaration when required, produce reports and writings demanded, or make your experts available for deposition, then the courts must exclude any evidence from said expert. Deposition is a part of pretrial litigation, set up by one of the parties of the lawsuit demanding sworn testimony of the opposing party, a witness to an event, or an expert intended to be called at trial by the opposition. What do I need to accomplish during this step? Once a party makes a demand, all parties must disclose their expert witness information to each other. Steps to complete the following. First, prepare your demand. You can accomplish this step by doing so on a 28-line pleading paper. There is no judicial counsel form for this procedure. One must create a relevant document on the pleading paper. The demand should include the title of the case, the party making the demand, the date of exchange of lists of expert trial witnesses, expert witness declarations, and any demanded production of writings. According to California Code of Civil Procedure, Section 2034.260, the exchange of information of expert witness shall include either of the following. Quotation. A list setting forth the name and address of a person whose expert opinion that the party expects to offer in evidence at the trial. A statement that the party does not presently intend to offer testimony of an expert witness. If a witness on this list is an expert as described in Subdivision B of Section 2034.210, the exchange shall also include or be accompanied by an expert witness declaration signed only by the attorney for the party designating the expert, or by the party if the party has no attorney. This declaration shall be under the penalty of perjury and shall contain all of the following. A brief narrative statement of the qualifications of each expert. A brief narrative statement of the general substance of the testimony that the expert is expected to give. A representation that the expert has agreed to testify at trial. a representation that the expert will be sufficiently familiar with the pending action to submit a meaningful oral deposition concerning the specific testimony, including an opinion and its basis, that the expert is expected to give at trial. A statement of the expert's hourly and daily fee for providing deposition testimony and for consulting with the retaining attorney. If you have already received a demand for expert witness information, you will skip the steps and begin at the last step. The next step is to make copies, which is simply making one photocopy of your demand for each party in the case. After, you would then proceed and have your demand served. A photocopy of your demand must be served to each party in the case. It may be served by mail or by a person not involved with the case who is over 18 years of age. The person serving your request must complete a proof of service form. A proof of service form is used to indicate to the court who is being served, when, where, and how that was done. Demands are not filed with the court. Keep your original demand and proof of service until 6 months after your final deposition of the case. If contents of the demand become relevant to any pending matter, then it will be presented to the court. Once the demand has been served, the next and last step is to exchange expert witness information. All parties must disclose information from all experts whose testimony will be used at trial. Once the demand is made, all parties in unison will exchange the names and addresses of every person who will give an expert opinion in trial. This exchange can be made through mail or at the meeting between parties. Remember, there is no judicial counsel form for this procedure. One must create a relevant document on a 28-line pleading paper. If any experts are a party, employee of the party, or is going to provide opinion at trial, the exchange of information must also include expert witness declaration. A declaration is all the expert witness information signed by the party. Who to send the demand to? After the 28-line pleading paper is prepared and photocopied, it is served to each party or the lawyer in the case, also known as the opposing party. Demands are not filed in the court, but kept until relevant in trial. Then they will be presented to the court. When to file the demand? It should be noted that a party must send out the demand for expert witness information no later than the 10th day after the trial date has been set or 70 days before the trial date. However, the expert witness data must be exchanged no later than 50 days before the initial trial date or 20 days after service of the demand, whichever is closer to the trial date. If the day falls on a weekend or a court holiday, the last day to make your demand is on the next court date closer to the trial date, unless the court orders an earlier or later exchange. How to file the demand? To reiterate, Designation of Expert is not filed with the court, but brought up when relevant in the court. However, in order to send out a demand to the other parties, one can do so by mail or by a person not associated with the case who is over 18 years of age. The person serving the demand must complete a proof of service. What is expected to happen next? After designation of expert is completed, what you can expect to happen next is based upon the time of designation. You would then proceed to schedule expert for deposition. Deposition for an expert witness is completion of the prosecution theory of the case, or the opposing party's defense. Deposition should take place within 75 miles of the courthouse where the action is pending, no later than 3 business days before the deposition. The expert witness shall produce any materials/category materials that was called for by the deposition notice. The party designating the expert is responsible for any fee charged by the expert for preparing for deposition, including travel. Templates/worksheet. A worksheet under the video is provided for free to fill out to go along with the video. Use the worksheet as a study aid to help better understand the information. Templates are provided at the bottom of the page to serve as examples of what a demand for designation of expert could look like and a rubric to help you understand the steps to take when designating an expert. For free access to templates, click either one of the buttons at the bottom of the page under the section labeled Forms/Templates. To conclude this section, here's a summary to serve as an overview. Designation of expert is the exchange of expert witness information between parties. The purpose of this step is to gain more information and prepare for trial. To do this, you will complete the following steps. prepare your demand, make copies, have your demand served, and exchange expert witness information. Based upon the time of designation, you would then schedule the expert for deposition. This has been an overview of the Law in Motion Designation Expert section. On the behalf of the ULB Justice Center, we thank you for your time and hope this information sparks some clarity in your legal matter.